of our dear viewers and listeners, thank you so much for choosing us. A very warm welcome to another edition of the program Conversations with Zelisa, where we continue to inform, educate, empower and answer those unanswered questions. So to all of our viewers on Synergy TV, all of our dear viewers on the Caribbean Showtime television in Canada, all of our listeners on the new U975 FM Multicultural Radio, Facebook and YouTube, thank you so much for choosing us, allowing us to influence you and add value in a positive way as we continue to inform, educate, empower and answer those unanswered questions. I'm Zelisa. You know, I always encourage you and I always remind you the importance of having pen and paper to take notes or your phone to, store important numbers. That will be helpful for you and your loved ones, all right? Directing this morning and in Master Control, Akua George, we'd like to wish each and every one of you a wonderful day today. It's the middle of the work week. It's Wednesday morning, Wednesday the 18th of January 2023. And I trust all is well with you. You're safe, you're happy, you're in good health, and you're having yourself a great day thus far, reminding you life is what you make of it. If you're celebrating a birthday today, happy birthday. If it's your anniversary, happy anniversary to you and yours. Happy Wednesday. Of course, let's go to our quote for today, and that's coming to us with the kind compliments of ZMB Communications Limited. And it says, live life to the fullest and focus on the positive. It says, live life to the fullest and focus on the positive. That's our message today. Sometimes we are bombarded with negativity. Sometimes you may hear something that will throw you off. But you just have to collect yourself, be positive, and move forward in full force. Yeah? So that came to us with the kind compliments of ZMB Communications Limited. Of course, wishing each and every one of you a great day today. We started a series on the law and you, and we've been doing exceptionally well with regards to reaching out and sharing information and helping people to gain knowledge, to understand circumstances and situations in a better way and how to move forward, don't procrastinate, and how to get things done the legal way. So let me say good morning and a very warm welcome. She's very much part of the program, both radio and television. Now a lot of people on radio call me and say, oh, I love listening to that lawyer. And I'm speaking of no other than attorney at law, Sajina Kadir. Good morning and a warm welcome.
Pleasant morning to everyone viewing and listening as well.
So nice to have you as always.
Always a pleasure to be here.
Same here. It's always a delight and blessing to have you. So last week we started a series on wills and probate. And you yourself saw and you understand how many people were very, very appreciative of the fact that we started this series, because now they have a great understanding and they get the opportunity as well to call in and interact.
There's a forum to actually ask their questions to get basic, understanding on the topic. It's very prevalent. So last 2 weeks we would have done letters of administration, what occurs when there is no will. So we thought it prudent today to explain what occurs when there is a will. So the heading for today will be wills and probate. So nice. I can explain what a will is, because people think a will is that the people named on it have title. A will only takes effect when it is probated. So a will actually only becomes relevant upon a person's passing. So just because a will has been done and beneficiaries are named, even if the person who makes the will dies, Zelisa, it does not mean that's my legal document to the property because I am the named beneficiary. No, you have to probate that will. So people go for years sometimes thinking that's their legal document covering a house, but it isn't. It's a will that takes effect only when somebody passes and has to be probated in order to be in order to regularize legal title to the lawful beneficiaries.
Understood, and that's great information to start things off with regards to, don't just take it for granted there's a will.
No.
There's a process, it has to be probated first.
Yes.
Great, excellent.
And a lot of people think, they could stay and just do a will, writing something on a paper, stating who they want to benefit. But a will must be properly executed in order to not be deemed void when the time comes in handy.
Right.
So how is a will drafted? A will has a testator or a testatrix. That is the person who is making the will is the testator if it's male and a testatrix if it's female. And that person who makes the will has to decide who they want to benefit any of their property. And their property could be land, monies in bank, insurance policies, furniture, fixtures, jewelry, anything that the person owns, that testator or testatrix owns, comes out in that will. And the will must name someone who is authorized to have that responsibility to apply to probate that will. So the person is called an executor or an executrix. So the testator or the testatrix is the person making the will. They name someone who they trust, who they know will do all the legalities to ensure that my beneficiaries get what my heart desires when I pass away, like that.
Right.
That person is called an executor if it's male and an executrix if it's female. And all persons you name thereafter to benefit from your property are called beneficiaries. So these are terms that come to life when you do a will.
Yeah.
And if you sit at home and try to do a will, it's going to be difficult. So it's always best to get that legal assistance to do it so that you are comfortable knowing what occurs to your property should you pass away.
Right.
You know? So, and a will, so it has a testator or testatrix, someone who, the executor or executrix, who is responsible for giving out the estate to do all the responsibilities legally, and then the beneficiaries. But a will must be witnessed in order for it to be valid. So though the testator or testatrix signs it,
yes,
if it's not witnessed by the appropriate witnesses, Zelisa, then it could be questionable in the future. And that's where issues arise.
All right. So if you decide right now, you're looking at the show, you're listening to the show, and you realize, you know what, I need to put things in place, and you get a pen and a piece of paper and you start writing, and I so-and-so of so-and-so, living so-and-so, this is my driver's license or my ID number, XYZ,
right.
Own this and this and this, and would like this to go to XYZ, whatever, and you think
it's fine,
it's fine. It isn't.
No.
You need to have someone to witness and to sign.
Because it comes like a comfort, but more so like a fool's comfort, Zelisa.
Yeah.
Because a will at the top must always have, this is my last will and testament, and revokes all former wills made. So if you go to a lawyer's office or an attorney's office, or a justice of the peace or a commissioner of affidavits, a legal consultant, whichever you choose to go to, once you apply, once you make a will today, you can change it tomorrow. So there must always be a clause at the top stating you revoke your last will.
Right.
And the will, in order to be valid, must be witnessed by 2 persons over the age of 18, Zelisa, who is not related to the person who made the will and not related to the beneficiaries. So you must really have your will drafted properly executed, and properly witnessed in order to be valid. Otherwise, unfortunately, what we spoke about last 2 series, regular law will take effect. So if all your life you want to gift your property, let's just say to Harry, who is not a relative. Harry is your gardener, and you just want to give it to Harry because he's been caring and stuff, right? And if you don't duly execute your will, and something is wrong with that will so that it is considered void in law, regular law take effect. So your spouse will get half, and the remaining half to the children equal shares.
Right.
So then Harry now will have nothing, and all this time he thought he would be the beneficiary. But if it's not properly drafted, there will be problems.
And today, let us remind you and let us plead with each and every one of you the importance of having a will. It's really important. It's going to save a lot of hassles when it comes to your loved ones. If you really love your loved ones, please put things in place.
I always tell people that, you know, because age shouldn't be a reason not to make a will, because life is so unpredictable.
Exactly.
You know, and you never know.
And we saw that especially when we were in the pandemic.
Do you
know what I mean? Yeah, a lot of people we didn't anticipate would pass.
Do you know, in my during my first COVID, I made my will.
You did?
Yeah, I did, because I felt so horrible. and I'm asthmatic, right?
Yeah.
So I just thought to myself, maybe I should just make it. So I always tell people, your will doesn't mean you're old. Your will means you're responsible and putting things in place in case something happens to you. Those who you love and care for will benefit from it.
I like that, and that's great advice.
It's always good to
especially
be
coming
prepared.
from someone as young,
Yeah,
and you know, ambitious and successful, but of course understanding the importance
that life is unpredictable. So it's always better to do a will.
I always tell people tomorrow is not promised.
That's exactly my line.
Yeah, tomorrow is not promised.
Yeah, so it's important. But when they actually endeavor to do it, don't feel like you know everything. Go to someone who could duly advise you how to make it, so it will be duly executed, duly witnessed, and there will be no issues to deem it void in the future. So no one will be arguing, or it won't become a contentious issue.
Nice.
Like that.
Great. Of course, this is the program Conversations with Zelisa, broadcasting on Synergy TV as well as the Caribbean Showtime Television in Canada, the new U975 FM Multicultural Radio. We've got different platforms as well as Facebook and YouTube. And you know, I know that some of you are ready and anxious to get started with regards to asking questions or concerns. Very soon we will be joined by attorney at law, Mr. Viren Sunarain, who's quite competent as well. Very ambitious young man, and you know, we are very fortunate to have two legal minds with us. Very, very fortunate. So, you know, of course, and continuing the series on wills and probate,
yes.
Explaining to us the importance of having a will,
yes.
the legality of it, what you need to do. You need to have a witness.
Yes.
And these are things that are important.
Right. So now that we know how to go about drafting a will, how it should be executed and stuff, once a person passes away is when the executor who's named in a will should, in a timely manner, usually within a year, so there's no real reason to file any affidavit of delay, should go ahead and take the responsibility assigned to him or her and apply to probate the will. So we will get into how to probate a will.
So do you must have an executor?
Yes, because you must name someone, the person who passes away must name someone in that will who I know will give it to the beneficiaries, because the beneficiaries will be hanging around there waiting for what they believe was going to be gifted to them. And if that person doesn't take the responsibility, sometimes the beneficiary may be a minor, so they don't have a voice of their own until they reach 18. Right. So there must be a responsible person over the age of 18 to actually administer the wishes of the person who passed away. So the procedures are quite similar to applying for letters of administration, because the first step will always be to do a search. Whether a will is left or not, there'll always be the first step in the probate section is to do a will in the name of the person who passed away to see if they deposited a will in the probate section. Because someone could have made a will today, and tomorrow go by another attorney or the same attorney, make another will and deposit that second will in the High Court. So therefore, we must make sure we get a stamped document from the probate section stating application made, no will found. So then we could now use the will that we have in our possession to probate that will, which is the second stage. So first will be the search, just like an application for letters of administration.
Right.
And now that there's a will, it's called an application to probate a will. Now, it's similar because it's an application for letters of administration. It's just the name changes, but it's very similar because it becomes a detailed affidavit explaining the person's link to the beneficiary, explaining that diligent searches was done to see if any will existed,
right,
and having an inventory, very similar to the application for letters of administration. The only difference is beneficiaries are named here, whereas with letters of administration, regular law under the Administration of Estate Act will apply when no beneficiaries are named.
Okay.
Right?
Good.
So once the actual application to probate a will is processed, a grant of probate is given. So the grant of probate will be in the name of the executor, the person who is responsible for administering this estate,
okay,
how this testator wanted it to be when he passes away.
Sure.
And then once we have the grant, you could actually go on to the next stage, which is like to do a deed of assent to regularize legal title if it's property, or you take the grant of probate to the licensing office so that the vehicle transfer will go from the person who passed away.
Understood.
Right? Or you take it to the bank so that they release the money, or whichever ministry somebody worked at, so they release the gratuity.
Good.
You know, like that.
Understood.
So once you have the grant, then that executor is still responsible for regularizing title.
Great. This is the program Conversations with Zelisa. Let's go to these important messages. When we return, we continue our conversation talking about wills and probate with learned attorney at law, Sajina Kadir, and joining us, Mr. Viren Sunarayan. Stay with us.
Master Eric provides the universal spiritual approach in ancient meditation techniques, chakra alignment and cleansing, home cleansings and exorcisms, treatment and removal of body pains, develop persons' spiritual gifts, and assist couples that cannot conceive, full medical body scans, and these are just a few services that are provided. If you need help, please call or WhatsApp Master Eric at 354-4459.
Visit Agri Savers Limited, number 19 Orange Grove Trace, St. Augustine, for all your agriculture, livestock, pet, agri-equipment, hydroponics, cannabis, fishing tackle supplies, and much more. Open Monday to Friday 7 a.m. to 5 p.m. and Saturdays 7 a.m. to 3 p.m. Contact 473-6074, 663-1094. Follow us on Facebook and Instagram.
The carnival season is upon us. Chutney Soca News, in collaboration with ZMB Communications Limited, is bringing the fun and excitement to you. We are throwing a studio party. Get ready for CSN Live. Live interviews, a live audience, live entertainment, and so much more. This and every Friday from 8 p.m. to 9 p.m. Broadcasting live on Facebook on Chutney Soca News TT, U97.5 FM, Multicultural Radio, and ZMB Communications. You can also look out for the rebroadcast on YouTube on ZMB Communications Limited and Chutney Soca News every Monday at 8 p.m.
Welcome to the Antediluvian Nature Center of Life Extension and Health Recovery. Coming from the Garden of Eden, the Antediluvian Nature Center brings to you breakthrough medicines and anti-aging technologies for all ailments and diseases in the body, nutritional therapies, naturopathic treatments, as we create opportunities of hope and celebrate longevity. And remember, the healing is from God.
Welcome back to the program Conversations with Zelisa. I'm in conversation with both attorneys at law, Sajina Kadir and Viren Sunarayan. Welcome back. Welcome to you, sir. Good morning. Nice that you could join us. I know this is a very busy morning for you all. I don't know how you're doing it, multitasking, but I guess it comes with the territory.
We love partnering, so we are here.
I'm very grateful. So today we're talking about wills and probate. Welcome, nice to have you with us, sir. I'm going to open up the telephone line. I know our viewers, our listeners are waiting to call in. 3847-142, that's 3847-142. Questions, concerns, comments. A gentle reminder before you call, please take the volume down on your television, take the volume down on your radio, then call in, speak into the phone and ask your question. Welcome.
Thank you.
So, your comments, your opening comments.
Well, I think it's something, the topic today is wills and probates. And I
Yes.
think that a will is something that everyone should really look to do before they pass. It doesn't matter their age, but it's something that it's a responsibility on you.
On the individual,
On the individual, yes.
Good morning and welcome. Yes, good morning. Hello.
Hello, good morning.
Good morning. What is your question, please, sir?
My question is, if you have a will and you haven't got somebody to look after that will. Hello?
Yes, we're listening, sir. You have a will, but you don't have someone to look after, you're saying. This is what you're asking.
Yeah.
Uh-huh.
What do you call that?
A poorly drafted will.
A poor...
The executor of the will.
You must have an executor named in the will, and that executor is charged with the responsibility to administer in the estate. However, if something is wrong with the that executor, you could actually apply for a substituted executor. But if no executor or executrix is named in the will, you have a poorly drafted will.
And I would also add, I think it's important to make sure that you let that person know that you've chosen them. Because I'm sure there are cases where only when the person dies, then you realize, what? I am the executor to the will, I don't know anything about it. So have a conversation with that person, let them know, let them be aware that this is their duty and responsibility.
That's right.
And to do it fairly as well.
Yes.
Of course.
Because that executor, it's good for that executor to have the original will with them. Because I mean, if they don't have the original will and have to use the copy, that in itself is a process. It takes, sometimes, I had a matter that took 8 months for an order to use a will, a copy of a will, to direct the probate section to accept the copy. So I mean, you must have the original, the executor should.
Yeah.
And that adds on to the time that it takes to probate a will.
Yeah.
Because as you were saying, that 8 months, you have to add maybe a year to that 8 months. So
that's right.
Okay, understood. Good morning and welcome.
Yeah.
Hello.
Hello, good morning.
Good morning.
Yes, I'm calling to find out if someone make a will, like a older person, and they didn't have an executor on it. Is it possible that you could do a will without an executor?
That was the question I asked before.
Right.
All right. So I want you to listen off air, and it's a good question because I did ask, and probably you didn't get the answer for it. Please, you must have. Please, yeah, it's important to have one. You must have. You must assign someone to be an executor on the will. It's important.
There must be an executor or executrix because somebody must be appointed to have that responsibility.
So if you don't, then that will is not valid?
It's very arguable by the next of kin. If that next of kin wasn't named as a beneficiary, it could become very contentious.
Okay. Yeah. Good morning and welcome.
Good morning, Zelisa.
Morning.
And your two guests.
Good morning.
What I want to find out this morning is about the difference between a will and a deed, because we have a deed, and so far I am not getting any problems in going around doing anything because my husband passed away and I had agreed with him that we will make a deed instead of a will. Will you please explain more on that?
The difference between a will and a deed. It's a good question. Thank you. Please.
Okay. So the difference is...
All the best.
Same to you. And
Happy New Year, dear. Sir, please, sir.
Right. So the difference between a will and a deed. A will is left behind upon the passing of someone, that there will be beneficiaries that will be entitled to their assets and possessions. However, a deed now, regarding to a piece of property also, a deed can be done and the property can be transferred whilst the person is alive. So you want a will to safeguard your assets and distribute it upon your passing. With a deed now, this is just a conveyance, or it can be done via a gift from one person to the other while they are alive. A dead man can do no deed.
Yes, a will leaves entitlement. It is not legal title until it is probated.
Okay.
A deed will be registered and is a legal instrument explaining title.
Good. Great. So I trust our viewers and our listeners understand what was just said with regards to the difference between a deed and a will. And there is a big difference. And that's why it's important to have a will. Again, we're going to ensure that we get that point across.
Yes.
It doesn't matter how old you are, it is important to put things in place. Good morning and welcome. Hello?
Hi.
Yes, welcome.
Morning.
Morning. What is your question, please?
Okay, my question is this. If you have a will, can you do anything before you die to prevent the long process of a will being probated?
To prevent what?
Could you please repeat your question, sir? We didn't get much clarity to that.
I'm saying that if you make a will,
yeah,
and before you die, is there anything that you could put in place to prevent the long process of a will being probated?
Okay.
Okay, good. All right. She's going to respond. Thank you, sir. Have a good day. Please.
It kind of took my thought. I wanted to raise this, sir. If the person made a will and they don't want their executor or executrix to take long to go by an attorney, pay a whole set of fees, do all this thing that taking so much time that he's saying, how it could be avoided? Well, if it's property, you can do a deed of gift whilst you're alive, so that it shortens the process. That might take about 2 months now to execute and register, pay stamp duties and register once everybody does their responsibilities. So the only way to avoid, it will take some time. I think since we have the virtual world, we're getting back grants quicker. Right? But if they want to ensure that no headache or hassle after, they should do the deed rather than just do a will and leave it to take effect when they pass away and then probate it and then do a deed of assent.
Okay, understood.
So do it while the person is alive.
Welcome to the program. Good morning.
I would like to...
Hello, you're breaking up.
About the deed. That person who passed away, would I be able to sell the property, or what do I have to do?
If the person what, sorry?
I would want you to please repeat the question because we did not hear what you said.
Okay.
No, you're breaking up badly. Unfortunately, I'll have to abort the call and ask you to call us back. Good morning and welcome.
Yeah, good day.
Yes.
I would like to ask you a question, please.
Please, go right ahead.
Okay. The question I want to ask is that my parents prepared a will, but my dad died, and my mother is still alive, and she wants to sell the property before the will is probated. What she has to do, does she have to do a deed of gift or agreement or what it is, so she could divide the property among her children?
Right, so just to be clear, his parents passed away.
Well, the father passed, the mother is alive and the mother wants to sell the property.
Okay, so from what I understand, I believe a will would have been made by his father.
There was a will, yes?
Right, so I think
Are you there, sir?
It's hung up.
No.
So the thing is, I'm not so sure. He just said a will was done.
Right.
He said his father passed away.
Yeah.
And he said they did not begin the process of probating.
Right.
So, but they want to sell the property from what I understand.
Yes, that's exactly what he said, sir.
So the question, what we have to look at is if that deed was in both of his parents' name and if the deed was via joint tenancy or tenants in common. So if it was joint tenancy and his father passed away and his mom was the only other person's name on the will or the deed, then his mom would have the power to transfer the property. But if it's father and mom were there and it's tenants in common, they have to probate the father's will.
Okay. You see that case and this gentleman, I would suggest you get an attorney.
Definitely.
Take the documents in because that's the exactly. That's the only way they could answer detail and give you, the answers that you are seeking.
That's
because
true.
you need there are certain things they need to understand.
And I want to add, because even if there are all these beneficiaries agreeing or consenting to renounce their rights or to sell it or whatsoever, they still need to have the relevant paper trail with the deed of assent and then a deed of conveyance. So it's endless questions and procedurally to put in place.
My suggestion is you get an attorney and get clarity, sit one-on-one so they could go through your paperwork, they could go through things in detail and answer that particular or those questions you may have. Let's go to these important messages. Thank you so much for choosing us. When we return, we continue our conversation. We continue to take your calls, both radio and television. And for those on radio, 384-7142, 384-7142. That's the number to call in. Stay with us.
Antediluvian Nature Center of Life Extension and Health Recovery. Coming from the Garden of Eden, the Antediluvian Nature Center brings to you breakthrough medicines and anti-aging technologies for all ailments and diseases in the body, nutritional therapies, naturopathic treatments, as we create opportunities of hope and celebrate longevity. And remember, the healing is from God.
This is Full 100, an all-natural herbal dietary supplement formulated exclusively for men. Our proprietary blend was designed with one goal in mind: to improve your overall health, rejuvenating your vitality, energy, strength, and libido. Want to be at your peak performance in everything you do? Then get Full 100. Fast-acting, long-lasting, with no side effects.
Oh my God. Trinity Service Center Company Limited, specializing in oil and fuel filters for both diesel and gasoline applications, automotive parts and accessories, making of key duplicates, servicing of both residential and commercial vehicles, which entails but is not limited to oil and filter change, underwash, engine wash, shock oil treatments, and much more. Fleet maintenance services. Come on down and check us out at LP number 602 Southern Main Road, St. Mary's Village, Karapichaima. Find us on Wheels. Contact us at 352-0469, 313-555-222-4098, or visit our Facebook page for more details. Open from Monday to Saturday, 7 a.m. to 5 p.m. and Sundays, 7 a.m. to 12 noon.
Agni Puja and Gift Shop, home to an extensive array of fine jewelry, books, authentic saris, and all your puja needs. Telephone 669-5058, located at Caroni North Bank Road, St. Helena.
On Saturday, 4th February, at the Center of Excellence in Macoya, feel the beat of soca and chutney on one stage.
Rub on the menu, we not here to pick and choose.
I love choca with Ravi B and Karma. Raymond Ramnarine and Dilly the Dan. Ding dong, ding dong. Sean Marshall, Irfan House, Rakesh Yankaran, the A-Team Band, Super Blue, Trinidad Killer, Temper, Iowa George, Nessa Preppy, Jadel, and much more. General tickets $300. VIP all-inclusive tickets $800. For more info, call 757-8265. Cool us in before 10 p.m. No glass bottles. Brought to you by the Massive Tank Productions in collaboration with Kadir Media.
I love choca.
Welcome back to the program Conversations with Zelisa, in conversation with learned attorney at law Mr. Viren Suryanarayan, and today we're talking about wills and probate. And so questions are coming in, sir, so of course let me go. Now I know there was something you wanted to speak about prior. Right.
So one of the initial callers who would have wanted to find out about how, instead of going through this long, lengthy process of probating, what is the fastest way he could begin to transfer everything? So I believe Ms. Kadir would have said, you could have done a deed, transfer your property to your children, if that may be the case. Right. And to add to that, we would say that, let's just say you're giving your children to put their name on the property instead of you before you pass. And you're unsure, maybe your daughter-in-law might want to kick you out of the property. You can take a life interest in the deed. So that would mean you would be in control of that property until the day you close your eyes.
Mr. Suryanarayan, I am very, very appreciative that you brought that point across, because it's very real and it's very true and it happens. The fact is, you may think, I want to give this to my children while I am alive so it could help them, because if they have a deed in their name or something like that, they could get a loan or they could build or they could do something. And this is what every parent would want to do, try to help their children. And by doing so, and the generosity and kindness of your heart, you put your children and you give them the rights. And what happens is that we've seen and we've heard time after time where children themselves put the parents out, or the father died, they put the mother out. So ensure that your wife or your husband has entitlements to stay in that property for life until they die, because there are situations where people are sleeping on the streets or living by other family members because they were kicked out of their own homes that they work hard for. And that's a reality, and I'm happy that you've raised that. So please be careful, take that advice and, you know, do what is right. A great morning, Zelisa and guests. Such a great, knowledgeable topic. To someone who has no knowledge on how to even start to prepare a will, is there an establishment we can visit to gain that directed guidance before selecting witnesses, and will it be expensive? Can you respond to this?
So doing a will generally is not expensive at all. It may cost you maybe around $1,500. Most attorneys generally have that price range.
Yeah, and that's affordable. I don't think that's bad at all.
Correct. And what the attorney will, that's also going to have the attorney explaining to you who you should really have on your will.
Right, you get some good advice.
You need to know of your beneficiaries.
Yes.
And the thing is, if you have about 5 children, and you did not include one of those children's name in that will, that's going to be contentious, because that will now, having excluded one child's name, is going to put the will into question.
But counsel, isn't it fair if you decide if you have 5 children and you don't want to give 2 anything, it's your choice?
But that's the thing. So you can decide to give them nothing, but you still must mention their name in the will. And you can say that you've provided for them throughout the course of your life, and you can leave nothing for them.
Okay, because there's some some children who are a little ungrateful and treat their parents bad.
Of course.
Right. Good morning all. My question, is it better to do a will or just do a new deed for the property, including the children as part owner? Because doing a will costs money, and then you have probate and then do another deed. Which is advisable if you know for sure what will be given to whom?
Okay, so I love the question.
It's a good question, yes.
It's obviously someone who's thinking right now about the future.
Exactly.
So my advice to you, if you have the money, do the deeds one time.
Okay.
Because you see, when you pass, or should you pass, your children are now going to have to wait for this long probate process to finally get their name on the property. And until that time comes, their children won't be the actual owners of the property. So should the children want to, you know, change the WASA names, TNTech names, go to the visa office.
Yes, exactly, you're correct.
These are things that I suggest, do the deed one time.
Okay.
Get it over with.
Another question, that's good advice. Good morning, I'm going through a divorce. The property is on my husband's name. Do I have rights on this property in the settlement? We have been married and living in the property for over 16 years.
Yes, she should. Obviously, we will need further, we need to ask some more questions of you. But you will have a form of entitlement, because you would have also provided something for the house over the last 16 years. So no one can just expect you to up and leave your house that you've been living, taking care of. She could have been painting that house. She could have spent a little bit of money to upkeep the house, simply cleaning the house, organizing, things like that. All of that contributes towards the house.
Okay. So good morning. I live on a property for 13 years plus and got put out after maintenance and paying bills, and the executor died but have children. Do they have to put us out just so after living there for many years?
That's the thing. It's a lot of questions we're going to have to ask with that one.
You see, this particular case, I also would suggest that you see an attorney, sit one-on-one, take the information and all these particular, there are details, you see, and they would need to ask in detail. All right, so to that viewer or caller, if you're listening, that would be my suggestion. It's a little complicated, so I would suggest you seek, you sit one-on-one with an attorney and get those questions.
A lot of questions needs to be asked, caller, and that's the thing. You said you've been there for 13 years. We also have to find out things like the circumstances under which you would have been put out. We'd also have to determine, if there was any agreements in place, enforced. Did he breach the agreement?
Good. So good morning and welcome.
Yes, good morning.
Good morning.
Zelisa,
yes, dear.
I want to know, ask the lawyer, if a person is an executor in a will, what that signifies, if the person could get anything.
Right. So, to answer your question, the executor of the will, that's the person who's responsible for the will and probating the will upon your passing.
Right.
So that executor does not have to be a beneficiary. That executor is the one person who goes to the attorney's office with the will to begin the process, and upon the grant of probate being granted, then the executor now will distribute the assets to those persons in the will who it was given to by the deceased person.
Right.
So
good. Excellent.
That is the whole purpose of the executor.
Okay. 3847-142. 3847-142. Questions, concerns. You could send your WhatsApp messages, as many people they've been doing, or you could call in and speak one-on-one. 3847-142. A gentle reminder, when you call, just take the volume down on your television or your radio and call in. Speak directly, all right? It says, good morning. My grandparents bought a house for my family when I was little. My stepfather paid back my grandfather, but my grandmother refused payment so that my mother and her children will always have a home. Years later, my mother found out that my stepfather put the deed on his name only. Unfortunately, my mother died before she could address this properly. Is it possible for my siblings and I to have rights in this home?
That's another one where
this is a little technical
you
as well.
See how much issues are coming up. Yeah. So I really suggest you do get an attorney, because we will need to look at the deeds. We will need to look at if you have any receipts that would have been made at that time when you're claiming that the grandfather would have collected the money and the grandmother did not.
Yeah.
So questions like this is what we're going to have to look at. We're going to have to look at even if any promises were made that you relied on, and that's why you continued sticking with that house.
Okay. So, okay, let's go to this and then I will read. Welcome. Hello.
Hello, good morning.
Morning. You need to take the volume down all about the call.
Hello, good morning.
Good morning. Can you take the volume down on your television?
You take the volume down.
What is your question, please? Hello? All right. All right. Hi. Let's say my husband and I are joint owners of property. He does not see it fit to make a will, saying when either one of us dies, the surviving one can then do. I'm not in agreement. Can I then make a will for my legal entitlement, which is 50%, or another option, can we both agree to do the will together?
Well, you see, now that's another one where we have a little issue, because they are joint tenants.
Right.
The principle of survivorship, it comes into play.
Right.
And now you're going to have to look at, she could sever her 50%, she could sever the joint tenancy by going to an attorney, doing a deed, and severing her joint tenancy.
Okay.
But, I mean, obviously, if it's between her and her husband, I think it's something that they could probably sort out on their own and make a decision.
Yeah, together.
Because, I mean, instead of going through all of that with the will and whatnot, I mean, survivorship already applies.
Okay, understood. So, quickly, let me go to this question. Welcome, good morning.
Hello, good morning, Zelisa. Good
morning
to the attorney at law.
Morning. What's your question, please, quickly?
Information with regards to a will that was made overseas. How does that apply to Trinidad and Tobago laws? And if the person who had made the will, my father, if he died, what steps do I take?
Caller, let me ask one question to you. You said that the will was made overseas, but was it a will for Trinidad and Tobago alone, or was it a will that was made for overseas assets alone?
Hello? Hello? All right.
So
Unfortunately,
I can
the
answer
person
the
is
question
not there.
in the meantime.
But I needed to hold it right there
Not a
because
problem.
we have our commitments. We need to take a short
Of
break.
course.
We'll address this when we return,
hello?
sir. Right. Let's go to these messages.
Yes. It's for here. I'm making one thing.
Hello? Hello?
Master Eric provides the universal spiritual approach in ancient meditation techniques, chakra alignment and cleansing, home cleansings and exorcisms, treatment and removal of body pains, develop persons' spiritual gifts, and assist couples that cannot conceive, full medical body scans, and these are just a few services that are provided. If you need help, please call or WhatsApp Master Eric at 354-4459.
The carnival season is upon us. Chutney Soca News, in collaboration with ZMB Communications Limited, is bringing the fun and excitement to you. We are throwing a studio party. Get ready for CSN Live. Live interviews, a live audience, live entertainment, and so much more. This and every Friday from 8 p.m. to 9 p.m. Broadcasting live on Facebook on Chutney Soca News TT, U97.5 FM, Multicultural Radio, and ZMB Communications. You can also look out for the rebroadcast on YouTube on ZMB Communications Limited and Chutney Soca News every Monday at 8 p.m.
Trinity Service Center Company Limited, specializing in oil and fuel filters for both diesel and gasoline applications, automotive parts and accessories, making of key duplicates, servicing of both residential and commercial vehicles, which entails but is not limited to oil and filter change, underwash, engine wash, shock oil treatments, and much more. Fleet maintenance services. Come on down and check us out at LP number 602 Southern Main Road, St. Mary's Village, Karapichaima. Find us on Waze. Contact us at 352-0469 313 555 222-4098 or visit our Facebook page for more details. Open from Monday to Saturday, 7 a.m. to 5 p.m. and Sundays, 7 a.m. to 12 noon.
Welcome back to Conversations with Zelisa. In conversation this morning with both attorneys at law. We're very fortunate. I don't know how they multitask, but they do it. Sajina, Kadir and Viren Sunarayan talking about wills and probate. Welcome back to both of you.
Thank you, Zelisa.
And let's go straight back to this call just prior to the break.
Of course.
Yes, welcome.
Hi, good afternoon, good day. Thanks for taking my call.
Okay.
With regards to...
Hello? All right.
Thanks for taking my call. I have a local lawyer that has seen about it, but so far, because I'm the only child my father has, the judge in High Court wants me to prove that he is my father, and I don't know any of my father's family, and my mother is dead.
Well,
so
please let's counsel.
So it's so unfortunate because I remember a judge telling me in a matter, it says Hall of Justice outside the High Court, but it's really Hall of Evidence. And if you don't have the evidence to link you to the person, or you don't have witness evidence from a relative stating that, corroborating supporting your statement that this was my father, then it will be difficult. Your only real witnesses will be friends, family friends. So she could try the application, but it will be an onerous or difficult task, because in order to prove the father, that person is the father, even if there are no relatives that you could find, you at least need 2 witnesses to link you to the person. Chances are the court may say advertise the application, and if nobody objects, then proceed accordingly.
Listen to this question. Good morning. If you put an executor in your will and when you die he tells beneficiaries he has no money to execute the will, what happens then?
So that's the thing, when a testator leaves somebody responsible, Zelisa, that person has to have the money to do the needful.
Exactly.
But if the beneficiaries find that the executor is taking too long, they can apply to substitute that executor. If they know the executor could go on oath and do an affidavit stating that I really don't have the money to do this. I renounce my duties here and I consent to this person now being willing to do it. But the beneficiaries must have no objections to that new person.
Okay.
Because they have to make sure that that new person doesn't create another delay.
Okay.
Yeah.
Good morning and welcome.
Yeah, morning.
Hello.
That my mom owns the property now, but she did a will before. But she wants to sell the property before she dies. So what I want to know, does she have to do an agreement that mirrors the will before she sells?
Whatever it is before engaging in any conveyancing matters, always better to err on caution and do the agreement.
Right.
But as counsel said, he should not blindly just listen to the advice this morning, because there are so many questions. You cannot go and sell a property, as counsel is saying, if it was in the joint name of the parents, then the other parent automatically benefits, and they have the sole responsibility of deciding if they could sell it. So you have to be, that person really needs to sit and speak with an attorney. It's not impossible, but procedurally things need to be put in place for it to be done properly.
Great. Good morning and welcome. Hello.
Hello, good morning.
Good morning.
Good morning to you, McKinney.
Good morning.
Could you tell me, if you're leaving a will to someone solely, could that person be the executor as well?
Or if the executor could be the beneficiary. I've done matters where the person is named. So the only conflict of interest that would exist would be if the person executing, witnessing the execution of the will is related to the testator or is related to the beneficiaries. But having one person you trust give it to themselves by a deed of assent after they probate that will, it's not unusual.
Okay, that's okay. So you could ask your son or daughter then.
Yeah, so they could be the one responsible and gift it to themselves, like that.
Good morning and welcome.
Hello?
Yes, welcome.
Is it Zelisa?
Yes, it is. What is your question?
Yeah. My father died on the leave of probate.
Yeah.
The probate came through on the 21st on the 20 January 2021.
Right.
She gives the sisters and them what belonging to them. I have a mentally challenged brother, which she did not give him anything. Because when we asked her about it, she said she has nothing to give him right now. She said she has to use that money to survey and to pay lawyers. The money what is in First Citizen was our big lump sum. That money was paid to the lawyer. We did not know surveillance. When Lynette Morat asked her,
don't call any names.
To do surveillance. She gave I just mentally challenged whether he has no money, they give him no money.
Okay, in the future, for you and others, please don't call any attorney names, please. I don't appreciate that, all right? Don't call the names of your attorneys, please.
So, just
so it is alleged.
Right, that's a correct word to use.
It is alleged that happened.
And if there are 5 lawful beneficiaries, even if one is mentally challenged, they are entitled to it. But if there is a court order that declared the person mentally challenged so that the person has a guardian to take care of him, of all his responsibilities, because he is so challenged, then the person owes the duty to give it to the person who's actually having that power by the court order to take care. So it doesn't seem like if there's a court order and that matters. So ideally she's supposed to give it, but in all fairness, if he is not of sound mind, it may be difficult. So procedurally things need to be put in place to make sure when he gets the money, he doesn't tear it up.
Right.
You understand?
Yeah.
So she definitely needs to have a proper conversation with an attorney to procedurally not have any ramifications for not gifting the estate how it's supposed to be in law to all equally.
Okay. 3847-142 questions, concerns 3847-142. Let's say one of the beneficiaries dies before the will is probated. What happens to his share?
Right.
That's a good question.
Yes.
It's a great question.
So, if one of the beneficiaries passed away, they would be entitled. But their share...
Who would be entitled?
Okay, so the beneficiary himself, the deceased person, doesn't lose his right. So, let's just say it was money, just to be simple here this morning.
Right.
Right, and it's $300,000 and that beneficiary is entitled to $100,000.
Yeah.
Because there are 3 children.
Right.
The next of kin of that beneficiary have to apply for letters of administration if the person who died, who is her husband then, or wife, didn't leave a will. So, and if they left a will, they have to apply to probate. It must take steps like that.
Understood. Good morning and welcome.
Good morning.
Good morning.
Hello?
Yes, welcome. What is your question, please? You see, you can't hear us because your television is on or your radio is on. And if you follow rules, we wouldn't have this problem. 3847-142 questions, concerns, comments. When you're calling, take the volume down on your television or your radio first. Then call, speak into the phone so we could get clarity and understand what you're saying. We're about the time where we're quickly approaching wrap up. Your closing comments.
Such a prevalent topic. The hour flies by and it seems
so
like
quickly.
members of the public really want the assistance. Your lines are blazing, Zelisa.
Yes, they are.
You know, but we look forward to continuing to partner with you to apprise the public on this a very live issue.
Good. Your closing comments for today.
Well, I'll go first. So, I would recommend for everyone to go and get an attorney. Make a will. Make a proper will. Yes, you can do a will on your own, but there are some procedures that you need to follow. And the creation of this will, again, it's to safeguard your assets for your future. It's to give it to your children to make sure that they get everything equally, or whoever you may want to give your assets to. So find an attorney, talk to them, and try and figure out where you want to go regarding your will and who you want to leave your assets to.
I endorse what counsel said, and we look forward to continuing to partnering with you.
Great. I want to thank both of you kindly. I know today and you've been extremely busy, but you make the time and energy and effort. God bless you all, guide you all, and we see you next week.
Same to you, Zelisa. Thank you.
Thank you so much. So this is where we've got to wrap things up. Thank you kindly for choosing us. We've got repeats of the program today at 3 o'clock on Synergy TV. And of course, you know, do what is right. Be responsible. Seek advice. Get help. Follow the law and respect the law of the land. Also, please wear your mask, sanitize, do what you're supposed to do. Here's reminding you that with God, all things are possible. I asked you to continue to listen to us on U975 FM Multicultural Radio as we continue to inform, educate, and empower. All right, stay with us as the journey continues. Thank you so much for choosing us.